prevented this accident, which they failed to do, and that is why we first itself in this case. But if we dig a bit deeper, you will see that the whole idea about a person not being able to duck, the moment the shot comes, it is completely false. It defies the laws of physics, because once a shot goes, it's not that it goes in light years speed. It comes in a speed of 10 25 kilometers per hour, and that is pretty much a person can see when it's coming, and if there's a disclaimer, he can bend down. And that is why we had a legal, yeah, I'll just conclude in like 2 minutes. We had 2 seconds. We had a legal claim while the defendant didn't, and that is why we already have won this case. And I hope the law also favors us. Thank you.
Thank you, Defendant Counsel. I think that concludes this round also. I think the organizers will let you know who the finalists are in a little while.
Are we supposed to wait in this meeting until the results are out, or how does it work?
Can one of the organizers please clarify?
I think Adarsh, you're on mute.
You will be having your final round now. Okay, so can you please wait?
Yeah, sure. Thanks.
Thank you.
Organizers, do you want to announce it? Do you want me to send you the finalists, or do you want me to say it myself? One of you,
No,
please.
no, no. You announce it yourself.
Okay. Not saying any of this out of formality, but I just totaled your scores, and it's all very, very neck to neck. It's really sad that we can't have multiple rounds of semifinals due to time constraints, because I would absolutely love that. All of you did really well, and these scores are just proof of it. It's truly, truly sad that only two of you can go forward. But the two people who will be going to the finals are Anurag and Manan. So if you guys could please unmute and switch on your videos so that we can get this final round also done.
Yeah.
Congratulations, both of you did really well, and let's hope that this tempo of yours carries on to the final round as well. So we have case 7 for them. Can we have case 7th then? We'll have Manan be the plaintiff and Anurag be the defendant.
Is this the case, Your Honor?
Yes, it is. You want me to tell you who the plaintiff and the defendant is, or have you guys figured it out? So the plaintiff here is Rahul, and the plaintiff will be Manan, and the defendant here is Steve because he's being sued, and that will be Anurag.
So your prep time starts.
I think that
No,
concludes
they have-
your prep time.
No, whenever I think twice now, it's last 15 seconds, so that they can.
Oh, okay. Hold on.
So it's time up now.
Oh, is it time up?
Yeah, done.
Okay, 1 second. Right. 3, 2, 1.
So, who's the plaintiff? I'm
Boundaries.
sorry, I got confused. Who's the plaintiff again?
It's me, Manan.
Oh, okay. Cool. Go on.
Right, okay. 3, 2, 1, go. Your Honor, the case today in front of the court is pretty simple. Well, my client, Rahul, first he constructed a statue in his front yard, and there were some pipelines that are owned by Steve, and these pipelines are there for a very long time. These have two deductive reasoning to it. Firstly, that they are pretty old, and secondly, there might have been previous thunderstorms, etc., and it has stood it perfectly. Now, why exactly is this a problem over here? Firstly, why is Stephen to be blamed? It is because this is purely a case of tort law, and I have two sets of argument. Firstly, the storms would have already occurred like long ago. I mean, this is not the first time rainfall and thunderstorms were happening, which means that these pipes could have actually stood them, and they have been tampered. I'm not making allegations over here. I'm just telling you that there was something wrong that happened this one time, and that is why it is very much possible that and that is why this cannot be claimed as the act of God itself, because this is not the first time it is happening, and for the act of God to happen, it should be of exceptional case, and that is why if the defendant comes over here and tells you that this was an act of God, you shouldn't be taking that into consideration. Secondly, he should have taken reasonable care by maintaining those pipelines because they're old, and they could have, and it's very possible that they would have got rusted. And as a result, it is very, very possible that they could have just and that would exactly happen. So now it was an obligation of Steve to maintain those pipes properly, but he failed to do so. Now what do we claim? We say that we need a reparation, we need a new we need the same statue be made and installed in the front. With this I would like to conclude. Thank you very much.
Thank you, plaintiff counsel. Defendant counsel, whenever you're ready, please start with your opening statement.
Your Honor, you can hear me, right?
Yes, you're audible.
Thank you, Your Honor. So, first of all, Your Honor, I would like to bring to you what the case says. If you can clearly read this case, it has just said that the statue was expensive. It has not stated when it was bought, nor has it stated what material was used to construct it. So, considering the fact that this accidental pipe leak has caused this statue to get damaged, means this is already not waterproof, or the material is somehow not withstandable against water. So, what is the preset that the petitioner has, that the rain and thunderstorm itself, or whatever, since the date of purchase is also not known, how many ever rains and thunderstorms that have happened all these years have not had a single chip on that statue. After all, that statue could have again been broken by the same water that the petitioner claims that my client's pipes have got into. This is my first point, Your Honor. Second point, the case also clearly states that the Steve constructed water pipes which he thought were strong enough. This is the same thing as saying that I have built a very strong house. It is your thinking that your house is strong. This does not mean that if an earthquake happens, your house can never crumble down. So he has thought that this can withstand natural phenomena. And to ensure that this happens, my client has clearly also taken periodic checkups. And this is clearly an accident and nothing less and nothing more. And hence my client, due to the points mentioned above, is clearly not liable. With that, I would like to conclude, Your Honor.
Thank you, defendant counsel. Plaintiff counsel, you have the floor to question the defendant counsel and vice versa. Madam, whenever you're ready.
Yes, 1 second. Okay, so firstly, oh yeah, right. So firstly, you said that my client just thought that those pipelines they were immune to like natural phenomena. But don't you think that if they have stood for so long, I mean for how many years, they have actually gone through all these natural calamities and still been there, so it was reasonable for my client to assume that they are strong? Yes or no?
So my reply to that is that, like I stated earlier, my client has taken measures to check up on his pipelines all this while. He has regularly checked up. Every single person who, even if you're owning a house, you would have regular checkups with your electrician, with your plumbers, everything, etc., to check if everything is working properly. So my client has clearly done his checkup, and if anything, the only person liable from all these arguments is my client's plumber and not my client himself. My client has taken measures to check especially since the pipes are old, to check whether the pipes are working. And this has hence clearly only been an accident and due to natural calamity and no fault of his own.
Okay. Yes.
Plaintiff
Yes.
counsel, do you want to follow up?
Yes, I do.
Go on.
Since in your answer you stated that the plumber is to be blamed, do you know that the employee and the servant rule, right? I mean, your client was the employee, so he should be held liable for his servant's actions over here. So are you telling me that we suing you is the right thing?
First of all, my client was not the employee; he was the employer. Second of all, the thing is that we are not employing people on a contractual basis for that to apply. Third thing is the plumber is clearly just a person hired by my client to check if everything is all right. And if the plumber reports that it is all right, then what? Then how can my client think that it is not all right? All he knows is that he trusted an expert, and the expert has given a decision based on which my client has worked. So this is clearly not my client's fault. And if anything is to be blamed, it's on the third party and not on my client. With that, I would like to conclude.
Defendant counsel, can you please clarify to me what you stated in your first answer? Something about why did the plaintiff counsel bring about master-servant relationship? What exactly did you say?
Defendant or plaintiff?
The plaintiff mentioned the
Yes.
master-servant relationship. Why did that come about? What were your exact words? What did you say?
You're asking the petitioner,
Yeah,
right?
I'm asking you. I'm asking the defendant counsel. Did you say
Yes.
something about a plumber?
Yes, because pipes are handled by plumbers.
Can you tell me what you said previously in its entirety?
What I said was the plumber is an expert in handling pipes, and my client trusted this expert, and whatever report the expert gave to him, he only acted based on that. So there is literally no fault on my client's side, since he has trusted an expert who has worked with pipes all this while, and my client has taken periodic checkups. So the petitioner cannot fault me there as well by saying that the periodic checkups were not taken, especially since I have mentioned that the pipes
Thank
were very
you.
old.
Thank you,
And
defendant counsel.
yes.
Defendant counsel, you now have the time to question the plaintiff counsel. So begin on your time.
Thank you, Your Honor. My first question is that, like I stated in my first statement, since the statue has broken by water leak from my pipe, and there is no specified date of what time it has been purchased, isn't it clear that in all this while, some form of protection to the statue would have been given, because it is clearly not waterproof, and there could have been n number of thunderstorms. And how is it certain that only this incident has made significant impact to the statue that you claim has been destroyed?
Okay.
Plaintiff counsel, could you answer?
Thank you for that question. Well, firstly, when there is a sudden outburst of water, if you don't know, counsel, there is going to be a lot of water like bursting out of those pipelines, right? And that force definitely has power to even cut the rock. And that is why I might agree with you when you say that there might have been some effects on the statue from the past itself. But what our claim over here is that the majority of the main reason why it actually broke was because this pipelines exploded, and that was in control of your client, and he failed to keep that in check, and that's the reason we're suing you.
Honor, petition for a follow-up.
Please, yes, defendant counsel, ask your
Thank you,
follow-up.
Your Honor. Since you have accepted yourself that there is chance that rain could have affected your statue, considering the statue was also exactly as put in this case very expensive, why wasn't any measures taken to protect it from being waterproof or making it waterproof? Why was you could have, if it's a small statue, you could have had a glass case covering it. If it was a big statue, you could have have galvanized it or something like that to prevent rust, or made it waterproof so that it just does not get destroyed by water. Even in rain, there's always wind and the power of rain to cut a rock. So my question is, why was
Okay,
any
yeah.
protection measures not taken for your expensive statue?
All right. Firstly, panel, thank you for that question. Panel, I don't know what world does the plaintiff, the defendant actually live in, because I don't know in any world whether rain can cut the statue. If at all anything, it can maybe just stick around on it and just make it a bit. I don't know, just make it a bit wet. And secondly, answering your question about how why didn't they cover it with glass? Well, if we wanted to cover it with glass, we would have just kept it in a museum. Statue. Have you ever seen any statue be covered with glass when it is in public? No. Or even if it is in a garden, you don't see it being covered with glasses and all. Because if glass itself breaks, then then the statue itself can break. What guarantee is it that the glass is not going to break?
Thank you, Plaintiff Counsel. Plaintiff Counsel, my question to you is, in your opening statement, you mentioned the concept of act of God. So, act of God is usually when an irresistible natural force causes any damage, in which case the defendant can plead it as a defense. Since it is clearly mentioned in this case that there was an unprecedented rainfall and thunderstorm, it's clear that the act of nature herein was obviously irresistible and unavoidable. And when such is the case, how do you claim that act of God is not applicable here?
Right.
How, on what grounds do you claim that act of God is not applicable and that it is indeed the defendant who is negligent?
Right. Okay. So, firstly, thank you for that question. Well, as I stated in my speech itself, act of God is taken into consideration when the act itself destroys the particular statue. But here, clearly, there was a middle element over there, which is essentially the pipes, and those are under the control of the plaintiff. Of the defendant. Why so? Because those pipes can be maintained by him, and if he had taken reasonable care in maintaining them, they wouldn't have burst as they did. And yes, moreover, act of God can be considered only when it is of an extreme nature, but a rainfall, Your Honor, cannot be of such an extreme nature that it simply just destroys a statue.
Thank you, Plaintiff Counsel. Defendant Counsel, my question to you is, you stated in your speeches multiple times that your client has indeed exhibited what would qualify as reasonable care, having called the plumber and etc. However, there is this concept called strict liability, wherein intent, knowledge, reasonable care are immaterial, and the person who causes said damage invokes something called strict liability. No subjectivity is taken into consideration. On what grounds do you argue that your client is not strictly liable for this act?
Thank you for that question, Your Honor. My client may be strict, could in this situation that you have described be strictly liable, but the fact remains that there was no protection on the statue. There's no single protection measure on the statue. They could, if the glass thing doesn't work, it's fine. Something else, anything else, just any kind of form of protection on the statue could be made. The plaintiff earlier asked, "How have you seen a statue? It's always in the open." I would like to say that it's always protected and kept out of public view, or even in public view. It's told there's a certain amount of protective degree that is maintained in the modern world by any person having an expensive statue. And considering the fact that my client had also taken enough care to protect to check up on the pipes, my client is not strictly liable because there is no form of protection, and this is simply an accident.
I have one more question for the Plaintiff Counsel.
Okay.
Plaintiff Counsel, can you please elaborate as to how the master servant rule in torts could be invoked in this present case? On what basis did the Plaintiff Counsel state said rule?
Yes. So, firstly, as stated by the defense, that their client had employed a plumber, and a plumber is essentially serving and giving his services to the employer, which was Steve in this case. And since Steve is paying him, he's in the procedure of
Counsel,
employment.
is a plumber usually employed or hired?
Okay, yeah, sure. Yeah, so he is hired.
Counsel, I
Anyhow,
want a straight answer. Is
yes, yes,
a
yes,
plumber
Ami.
usually employed or hired?
Hired.
Okay, what is the difference between employed and hired?
Hiring can be for one-time use, and employment can be for multiple times.
Correct.
So
So when you hire someone, it's for a particular task. After the accomplishment of that task, they cease to be, of use. Employment is a prolonged service of duty, correct? So the master servant relationship, do you think it can be invoked in a case where a person has been hired and not employed?
yes, panel. Actually, it can be, because it has happened in the past before, where I don't remember the exact details of the case, but there was the primary employer, there was a secondary employer, and there was this person who was employed for a temporary task of fixing pipelines or something, and he had messed up the entire process of fixing those pipelines, or had caused some damage, and still the primary employer was held accountable. I know that it is a separate concept, but still, for one-time use, for one-time employment, also this particular rule is applicable,
Okay,
because in
I have
general,
one more question for you, plaintiff
yes,
counsel. So, when the servant, person who has been employed, this person commits a wrong, well, either a civil or a criminal wrong, and then the master is also vicariously held liable. Here, the person as such has not committed a wrong, and moreover, there is no established master servant relationship that exists here. So, thank you for your explanation. So, if we could please have the defendant counsel go on with their closing statement.
Yes, Your Honor. So, first of all, I like to point out the fact that, once again, like mentioned earlier, no preventive measures was taken. Okay, let's forget rain. What if there was a tornado or a 150 km/h cyclone? At that time, the statue would have just flown away and broken itself. So, just because water from the pipes of my client has hit doesn't mean that protective measures cannot be put and should not be put. That is my first point. My second point is that the pipelines of my client were periodically checked by my client using experts that he had hired. And because of that, he has only believed what the expert says. He cannot he cannot obviously say something on his own like the pipes are amazing, since my client is not a plumber. That's like saying you are completely all right to another person when you're clearly not a doctor, or declaring someone dead when you're not a doctor. Same way, my client has clearly hired a professional expert to assess what has happened, to assess how the conditions of his pipes are, and that clearly shows that my client has taken a reasonable amount of measures to prevent any mishap. So any mishaps that has happened is not the wrongdoing of my client, especially since by point one again there has been no preventive measures, and hence I would like to state that this is all clearly just a coincidence or clearly just an accident, and my client is not liable for any of it. With that, I would like to conclude, Your Honor.
Thank you, defendant counsel. Plaintiff counsel, if you could please go on with your closing statement.
yes. Yeah, 1 second. Okay, 3, 2, 1, go. Well, panel, let's actually look at what the defendant actually told you today. They came and told you that there was reasonable care taken by their client, and secondly, that we should have done our job of protecting a statue. Well, this entire case falls apart because of one reason, and it is because we as the plaintiffs couldn't have taken reasonable care in order to prevent a statue, because in just establishing the statue and keeping it in our front yard, which is our own private property, itself is enough for a reasonable for taking reasonable measures in order to ensure that our property does not get damaged. Despite of that reasonable care, it still got damaged because of the negligence of the defendant, which is essentially defendant's client, and it was because of him not taking care of those pipelines properly, because it's clearly evident that these kind of rainfalls would have happened for a very long time, and that is why it is very much, yeah, I'm just concluding, it is very much possible that this would have happened already. The pipelines were worn out and they still did not bother to keep them in check, and that is why we believe that we already have won this case.
Thank you, Jane Tech Council. I think that concludes the entire round. Does it? Yeah, I think it does.
Ma'am, I
Very-
actually have a doubt. I have a
Yeah.
doubt regarding vicarious liability. Actually, the thing is, it is the negligence of the plumber, right? I mean, over there, plumber was employed.
Yep.
So that is up for debate because a plumber is reasonably educated to give a vote of confidence or to say no, this has to be rectified, correct?
Yes.
So since the existence of a plumber has been newly introduced into the case, that is inherently, you don't see it in the case law, right? So the assumption that we are presented with right here is that the plumber, who is reasonably educated to have an opinion, has given his vote of confidence here, which means his job in therein. If say I hire a plumber and that plumber goes and breaks your statue, then I can be held liable, correct? Because he's committing a crime whilst being employed by me, hired by me, that is. But the hiring is again only under exceptional circumstances. You can only invoke master-servant relationship, that particular sort of vicarious liability, when there is an employee. Say my driver isn't okay, my driver is driving me to work, and when he drives, he causes an accident. There, I will also be held liable because I've employed him. My driver is not hired, he's employed by me. So, or if I say I have a house help who is permanently employed in my house, and my house help causes a civil wrong or a criminal wrong, there I can also be vicariously held liable. That doesn't mean the house help won't be held liable. He or she will also be held liable, but vicariously I will also be held liable. Here, that particular concept can't be invoked because he is temporarily hired, first of all, and second of all, he hasn't directly committed a crime. There is no negligence that you can establish on the part of the plumber, and without the establishment of a negligent behavior on his part, you can't go ahead and invoke other relationships. Is
Okay.
that clear?
Yeah. But still, I mean, I still don't understand how there's no negligence on the part of plumber, because if he would have done his job, then this wouldn't have been a problem itself, right?
Yeah, exactly.
So I'll tell you what. This case is the exact case facts of a case called Blythe versus Birmingham Water Works. Okay.
Okay.
So in this particular case, what the case is immaterial, okay, because that doesn't really affect your argument or how you argue. But in this particular case, it was actually held that the defendant can't be held liable because it is an act of God. Because even if the plumber, who has been newly introduced herein, had taken reasonable care to ensure that these pipes were properly maintained and they were safe to be used, an unprecedented rainfall, your keyword here was the unprecedented rainfall. That is nothing, no one could have predicted or nothing could have anticipated this. So the plumber thing is secondary, and even if the plumber had given his go word, it still doesn't matter because you can't prove negligence on his part.
All right. Okay. Right.
Okay.
But anyways, please don't consider that as my main claim, because that just came up as a rebuttal.
I mean, I did tell you not to use legal concepts. You're not entirely sure.
I mean, you can't stop when you're studying law, right?
Oh yes,
You
very effective.
understand that.
I'm sure it is. Yeah, but this is the case law. You can go read it up if you want. It's called Blythe versus Birmingham
sure.
Water Works. Okay, I think the organizers will let you know about the results. Very well done, both of you. I had a tough time marking the both of you because one of you asked a really good question and then the other also followed it up by answering it really well. So I think the organizers will let you know. But other than that, really well done. And I don't know if the rest of the participants are all here, but if you want personal comments or opinions or anything, let one of the organizers know and I'll send it to them, and then you can get it.
So should we send it in the group if you want personal opinion?
Yeah, ask one of the organizers and then I think they'll contact me and I'll let you guys know. Very well
Sure.
done, all of you. This is very nice.
Thank you.
Yeah.
Thank you.
Yeah, thank you, participants, and
Yeah,
everybody
yeah.
did well, and thank you, Jits, for judging them,
Thank you.
being a part of this.